Hello and good morning, everyone. Welcome to EBC Learning. This is our fourth class on AIPR, and today we are going to discuss the criteria for patents, practitioner's perspective, prior art search. And we have with us Dr. Shivani Srivastava. I just want to introduce you to Dr. Srivastava to you all. She's a registered patent agent with over 16 years experience. She holds a PhD in bioinformatics, MSc in plant science along with LLB degree. She has also done an executive program TLPWE from IIM Calcutta. Her technical areas of expertise include plant science, chemistry, biotechnology, bacteriology, medicine, and biotechnology medicines products. She regularly advises the clients on filing and prosecuting patent applications in India and foreign jurisdictions. She works closely with clients and manages their IP portfolio. She has expertise mentoring individuals, startups, SMEs, and advising them on building IP strategy and portfolio management. She's also involved in IP related business deals, which include IP valuation, due diligence, technology transfer, licensing, etc. She's published several articles and delivered lectures at various forums. Thank you so much, Dr. Shivani, for joining us today. I'm sure it's going to be a great discussion. And as you know, it's a small group. We would have, I'm sure, a good interaction with each other. I'll just hand it over to you, Dr. Shivani. Over to you. Thank you so much.
Thank you so much. Thank you for the lovely introductions. And I understand this is the fourth session, so the basic of IPR has already been covered, right? Please let me know when you can see it.
Yes, we can see.
Okay. So I think for the patent, this is the first session. I'll try to cover this. Maybe the language should not be very technical or the legal, because I understand the people doesn't have a technical or deep technical and legal background. So for IPR, so you have already checked this one. So there are different forms of IPR: patents, trademark, industrial design, copyright, trade secret, semiconductor IC layout design, plant variety protection, and geographical indication. So patents is basically for the inventions or the innovations. It's more on the technological side of it. Trademarks are for brands or anything which is being used to promote the business. Industrial designs is for the designs, look and feel of the design. It doesn't cover the functional aspects of the design. And the copyright is for all literary, artistic, and cinematographic work. Trade secret, so there is no as such law in India to protect the trade secret. If someone wants to protect it, they will have to keep it secret. There is no additional options to get a protection from the government on that. And then there is one semiconductor IC layout design. So there is a registry which protect to help IC layout designs. Plant variety protection is for any varieties, plant varieties which are created by the farmers can also be registered. And geographical indication, so there are products which are famous or which have a special characteristics because of the geographical region they are originated. So those are being covered under geographical indication. So out of these, so patent, trademark, design, copyright, semiconductor, all these are being awarded or registered to a person or the company. But when we are talking about plant variety protection or geographical indication, these are not being assigned to one person. Those plant variety is for a group of farmers, and geographical indication is for the artisans who are working on this. So this is more like multiple people are involved here. So when we are talking about the patents, you can see, so we can see how the human inventions have been evolved. So this is an example which is covering for the wheel. So if you say there was a cart wheel kind of thing, and then it evaluate to the cycle, then car, and now we can see there are advanced version of cars available. And so we see like how did we evaluate that, how's the evaluation is happening on the technology or innovation side of it. So we see there is a knowledge which is already there. Okay, people which are, there are certain things which are already being used by human beings, plus when we add human innovation on it, we come up with a new invention or a new technology which is advanced version of the existing technology. So if we see like what is the sources or the process which is used in idea generation, it could be based on the group discussions, because we see in the offices or in even R&D labs, people sit together and discuss about the things, and then they all together come up with a uh, tech, maybe technical solution of an existing problem. Or if we are looking for a specific product feature, we can come up with a new invention, sometimes based on the voice of customers. Okay, suppose there is already a product or process in the market, and there are some more requirements from customer side, so on that also sometimes the inventors are coming up with the new invention. It can also be through the market study. So we study what is happening in the market, and when we want to change something or come up with something new, so after the market study, we can come up with the new invention. And technology landscape. So I will briefly explain what is technology landscape. In this, we study the technology maybe for 10 years or 20 years. We see how the graph of the technology is moving, how the technology is getting evolved with time, and based on that we can work on the similar technology and then come up with this new invention or new innovative ideas. Competitor watch is very important, where we just keep an eye on the competitors, what kind of products or process they are using, and based on that we can also work on the similar or advanced version of the products. And literature know-how, there are already so much literature available in the form of technical journals, technical publications, articles, and the patent document. We can read all those documents and then see if further inventions can be done or further discoveries can be done based on that. So one which is very important to understand, why should we protect our innovation? One thing, it brings the competitive edge and more market power, because when you have a monopoly, so that means you will be the only one player available in the market with that particular invention, and the other competitors, they won't be able to use it because you have a patent on that. The other importance of the patent is to recognize the inventors. So when we talk about the patents, there are two things. One will be the owner of the patent, and then there are inventors who worked on it. Sometimes the inventors and the owner is same, but sometimes the inventors may be the employees of the company who are working on a project and coming up with a patentable invention, while the company will become the owner of the patent because they have funded everything. So in that scenario, the patent is actually recognizing the work of the inventors. And a patented invention could be an additional revenue system for the business. It also helps to raise funds and attract potential investments. So if you have an idea about the startups currently, so when they go and look for the investment, when they are talking to the investors, so like almost every investor is asking about the IP in the name of the company. They every time they, okay, how many IPs are there in the company in the form of the patents or trademarks or copyrights. So the person who has protected everything, there are high chances they would be getting good investments. So if I give you an example, this is a very good live example for the patent, like how does it help? So this Ramel France from Ohio, he was out for a picnic with the family, and he forgot to carry the can opener. So earlier the cans were not with the pull-up ring. It's like completely covered box, and we need a can opener to open it. So he was facing issue, and then he came up with a new invention, which it in the form of that pull-up ring, which can be put in the on the can cover, for that you do not need a can opener. And so that time a war, like as always, there was a war happening with PepsiCo and Coke, and both the companies has actually contacted him to buy the patent. So the person, the inventor, he did not agree to sell the patent, but he agreed to give the license. So what he proposed, okay, I can give you the license, you can use my this pull-up ring on the product on your cans, and I will take 1/10 of a penny per can. So the company agreed, okay, so 1/10 of the penny is okay, we can give it. So during the time period of validity of the patent, the inventor actually obtained 148,000 UK pounds a day on royalty. So you can consider this was a kind of the more revenue they were making. And he was not spending any money on that. He was just, so when we are talking about the revenue, he just invented once, got the patent on that. He gave the license to the companies, and he started getting revenue in the form of the royalty. So this you can see like how strong the invention and how can be it beneficial for the company or the inventor. So when we say like what is the patent? So patent is a grant or a right. It's being awarded by the government to a person who created it, giving an exclusive right to stop others making, using, offering for sale, selling, and importing an invention for a limited period in exchange for disclosing it in a patent specification such that anyone having average skill in the art can reproduce the invention. Okay, so I understand this language is not easy. I'll try to explain it in simple language. So one, the patent is being awarded by the government. So it's a patent office in India which is awarding a patent. And so once you have a granted patent, you are getting an exclusive right where you can stop anyone else to use the invention without your permission, okay, or without any authorization from you. And it is given for an invention. I'll explain the definition of the invention in next slides. And this is for a limited period. So limited period is like 20 years from the date of filing in exchange for disclosing, okay? So the thing we need to understand, why is government giving you the rights like monopoly for a certain period? Because you will have to give your invention, and government is giving you right for 20 years, so that after 20 years the invention will go to public. Okay, so finally this is the society who will be getting advantage of the system once your monopoly is over. So when we are talking about the invention disclosure, so it should be sufficient. So when I say sufficient, that means any person having average skill in the art, or person who is having a like average knowledge of that particular technology, should be able to reproduce the invention after reading the document, so that when the patent is expired, so the public who can read the document, they should be able to duplicate it. Otherwise there is no option. If the information is not sufficient in the patent document which is submitted at the time of filing, the government will not award it. There will be objections on that. So patent is, so most of the time when we are talking about the rights, it's mostly positive rights where you enjoy your rights. Okay, so it always talk, okay, if you have rights, what all you can do. But the patent is called as a negative right because it is giving you right to stop others. Okay, and only the owner of the patent has qualified right to use the invention. So these are the key features that I have already covered. So the patent is for the protection of idea, that innovative idea. The time period is 20 years. The protection, it gives you a protection to stop others from reverse engineering of the product. It gives you a high value of protections. I gave you the example of that opener. You can understand the kind of value created once the patent is awarded. And after the grant of the patent, it gives you the 20 years. So 20 years starts from the date of filing, and but it will be effectual once the patent is granted. And one important feature is patent is a territorial right. So when we say territorial in nature, that means there is a geographical boundary of it. If the patent is being granted by the Indian government, it will be applicable only in India. That means if you have granted patent in India and if someone is copying the invention in US, you won't be able to take any action unless you have a separate patent granted in US. So that means the territorial right. So there are certain things what can be patented and what cannot be patented. Okay, so I said invention. So inventions can be patented. So what is the definition of the invention? The invention relating to a process or a product that is not included in the category of inventions for which patent protection is prescribed. Okay, so invention is basically the new and inventive, which is new and has inventive feature in it, and it should be able to used in any kind of industry. Then there are certain things which cannot be patented. So section 3 and section 4 of the patent acts uh, talk about the things which are not being considered as an invention. So if they are not an invention, it cannot be protected under patents law. So what are the basic criteria of patentability of an invention? Novelty, non-obviousness, or it should have an inventive step, and industrial application. I'll cover these one by one. So novelty means the invention must be new. So when I say it should be new, that means it should not be available with public in any kind of publication, or the product should not be available anywhere in the world. Doesn't mean, say, if we are filing a patent application in India, the novelty is always worldwide. It doesn't mean if the invention is not new in India, but it is already used in other countries, no one can get patent on it. Okay, so novelty is dependent on state of prior art. Prior art means any prior publication with respect to the invention will not be considered as a new invention. If you have any questions in between, you can ask. Otherwise, we can take questions at the end as well. So then we talk about the second criteria, which is inventive step. So inventive step is a feature of an invention that provides a technical advancement or economic significance, or both. So there is a difference between novelty and inventive step. When we talk about the novelty, that means the features of the product are exactly present in the available prior art. But when we are talking about the inventive step, that means the person who has ordinary skill in the art, the invention should not be obvious for the person. So we the term we use it is like falsita. So we say, can you see the cursor moving?
Yeah, you can see.
So this is the prior art which was already there, and maybe this was the other kind of prior art which is already available. And then this is the person, okay, who has ordinary skill in the art. Okay, so the person like having expertise in particular technology. So he's combining three things. Okay, he's using two kinds of prior arts available, plus he's using his skills and knowledge on it, and he's coming up with an invention. Okay, so this invention will be considered as a patentable invention, or an invention that has inventive step. Okay, so if there is like this plus this, will not be considered as an invention, because he is just combining these two. But the moment he is adding his skills on it, it will be considered as an invention. The third and very important criteria is industrial applicability. So the invention for which we are seeking a patent protection should be able to used in any, at least in one industry. Okay, if the invention has certain things, even if it is novel and it is inventive, but it may not be able to used in any industry, it won't be considered for a patent. So one example is perpetual motion machine. So so perpetual motion machine is, so in the machine when we talk, so there will be input and then we get output of it. Okay, or when we are generating force, then the machine will start working. But when we are talking about perpetual motion machine, that will work without even giving any outside force. So that may be considered as a new, because these machines are not there, and it can also be considered as inventive, but this kind of machine is not useful in any industry. So that in that case, if there is any invention related to this kind of machine, it will not be considered for patent. Then I said, like, section 3 and 4 talks about the things which are not an invention and therefore cannot be considered for patent. So I covered them briefly. I'll not explain in detail. So anything which is frivolous or contrary to natural laws. Okay. So we have Einstein laws and all other known laws. So if there is any invention which talks opposite or contrary to that, it will not be considered as an invention, and therefore you cannot get patent on that. The other point is contrary to public morality. Okay, so anything which is contrary to public morality or environmental health or public health, that will not be considered for patent. So if I give you an example of it, so against public morality, if there is a device, a theft device, okay, which is helping people to do take things from others, okay, so theft device will be considered against public morality and order. It will not be allowed. And if anything which is not good for the government or public health, for example, if there is a device or a process related to oxygen depletion, that will not be considered for patent, because oxygen depletion is not good for the environment and also for the human and animals. And then new form of a known substance. Okay, so this is very important for chemical inventions or pharmaceutical inventions. So any new form of a known substance is not being considered as patentable invention unless there are some additional features of it. So when I say new form, so in that case, if there is a medicine which is available in the powder form, and then there is another person who is coming up with a capsule or tablet form of it, or maybe in a liquid form, that may not be considered as an invention, because you are just changing the form and all other features are same. And then other kind of is if there is an admixture. Okay, admixture means we are combining two known components, and the final result is coming up with the obvious results. Okay, so if I give you like very simple example, we make a lemonade at our home. So for the lemonade, we add lemon water and sugar, and when the final product has all the features, there's a water component and there is a taste of lemon and sugar. So this is being known as mere admixture. Okay, so but if I say, if I'm adding sugar and water and it has sour taste, okay, that can be considered as a different feature which was not there when we simply add sugar and water. But for any components showing their own features will not be considered. And then rear arrangement or rearrangement of devices where all the parts are working independently is not an invention. A very simple example is maybe an umbrella with a torch, where and both are working independently. Okay, so when we use the umbrella, we can just open the umbrella and use it. And at night, we are using the torch function of it. So there is nothing innovation. Okay, so I have just added one additional feature and performing the same properties which is already known, so it will not be considered an invention. Next is method of agriculture or horticulture. Okay, so method of agriculture means how we are doing it, like how to sow the seeds, when to cut it, when to water it. All these comes under method of agriculture. Or if we say the mountains, there is a different agriculture method being used. For these things, patent will not be awarded. Traditional knowledge, anything which is already known traditionally, is not being considered under patent. Then mathematical method, business method, computer program per se or algorithm, these are not being considered as inventions and therefore no patent on that. So mostly see currently like every startup or almost all the companies are coming up with AI related inventions, which is mostly computer program or algorithm. So when we talk about computer program per se, means there is a software. Softwares are a method, just a process of instruction. There's a set of instructions. When we talk about it, it is not patentable. But when we say, okay, so there is a computer software associated with a computer hardware performing an additional feature, then it can be patented. Okay, so there all these non-patentable inventions are there, but we will have to see, okay, so this particular thing is not patentable, but we add other things, it may become a patentable invention. Then presentation of information or graphical user interface, these are not considered as an invention. Literary, dramatic, artistic, and musical work, all this comes under copyright and therefore not patentable. Atomic energies, so that is section 4, which talks about any invention related to atomic energy will not be considered for patent. Then method of treatment. Okay, so when we say method of treatment or method of doing surgery, diagnostic methods, all these methods are not invention, but maybe the devices and instruments used, all these can be patented. But when I say method of treatment, so method of treatment is a doctor is giving the prescription, giving a medicine and saying, okay, you will have to take the medicine thrice a day. Okay, so when he's saying that take the medicine thrice a day, that is method of treatment. That is not patentable. But we can obviously get the patent on the product, on the medicine, or the method of manufacturing the medicine. All these can be patented. If you need any clarification on that, you can ask, because like I tried covering this in like simple things, but I'm not sure if it's clear to you.
Okay. Brilliant.
Okay.
Ma'am, does algorithm gets patented?
That's what I said. If this is only algorithm, then it comes under copyright work. But when we say, okay, how the algorithm is being involved with the system to solve a technical problem, then we can get patent on that. So
Okay.
it should be there. So algorithm is just a part of the software. When we talk about the patent or invention, it should be the combination of software plus hardware.
Okay. Also, musical instruments, does that get
Musical
patented?
instruments, if we can prove there is a novel and inventive features in it, we can get it.
Okay.
If
Thank
these
you.
are normal musical instruments which are already there, then it would be difficult. And sometimes there are maybe only the structural changes. Okay, there may be a design change in the musical instrument. In that case, a design registration can be done and not the patent.
Okay. Thank you, ma'am.
Okay. So, what is the prior art? Because we were talking about the novelty and the prior art. So, any information which is available to public before filing patent of application would be considered as the prior art. Okay, it may be in the form of research articles or patent document, web pages, books, journals, in any form. And it is not based on the territory. Okay, that's what I said. The novelty will always be considered worldwide. So if you are filing in any subject matter which is available in US and already published in US, and you are filing the patent application in India, so the invention will not be considered new, because sometimes the customers which comes to us, they say, okay, I want to protect this particular product in India, Though the product is already being sold in China and other countries, then we will have to explain them now. So because sometimes it's difficult, they say, but it is not in India. So we say, okay, it is not in India. You can sell it in India, but for patent, it should be new. And if the product is available in any other country, it will not be considered as a new product. And so existing relevant technology, that's the prior art where people already know about it. It can be your own technology or act. So sometimes people say, okay, I have published a paper, now I want to file the patent application. And we say it is not new because it is already published. Then they would be asking, but it's our own publication. So it doesn't matter who published it, okay? If it is accessible to public, it can kill the novelty. So if someone wants to file a patent application, the first thing is you should file a patent application and then start talking about the invention to others, maybe verbally or through any of the publications. So next, we are starting for the next section, the patentability search. So if you want to ask anything about the patent or the criteria, you can ask. Or should I proceed with the next part?
Yeah, you can proceed, and at the end, I think end of the slide, we'll discuss. Any point is there, then I'll come back. I'll be come back to you definitely.
Sure. So when we talk about the patent search, so one, we need to understand why are we conducting a patent search. One important thing when we are filing patent application, we need to understand whether the patent is new or inventive. For that, we should understand what is already there in public. Okay, so for the novelty, if we see if the similar invention is already there. For inventive step, we will have to understand if my invention is the combination of the existing prior art. So there could be different kind of patentability search or patent search. It can be a normal patent landscape or freedom to operate analysis, validity or invalidity search, patentability search, and then there are other kind of searches, maybe a knockout search, infringement search, equivalent search, backfire risk analysis search. So prior art is the document which is available or accessible to public. Okay, the information can be published in a document or it can be through an act as well, because if you haven't published it but you have told other people about the invention, so that can also be considered as disclosure. It can be in the form of a patent or non-patent literature, and there is no time limit for it. Okay, so if there is any information maybe which was published 50 years back or maybe 5 days back before filing patent application, everything will be considered as published document. And there is no restriction on language of publication. So if the invention or the prior art is published in Chinese language, still it will be considered. And most of the times there are many Chinese patents which are cited during the examination by the examiner. So I said act can be the oral presentation in seminar or demonstration of invention in public, because in this scenario you are not, there is no published document available, but based on your act, because your presentation or if you have disclosed the invention in the public, then it would be considered as disclosure. So there is an option available in Patents Act. So sometimes if the invention is related to some kind of product which is required, because for that, if you want to check whether the product is functional or not functional, you will have to use try it. So if the invention is being used for a trial purpose, it will not be considered as disclosure. Because for example, if there is any invention which is maybe related to train, so if they want to check whether it is working successfully or not, they will have to run it. Okay, that in those things, it is, if the use was for trial purpose, it will not be considered as killing the novelty of the invention. So these are the kind of searches. So patentability search we do before filing patent application to check the inventive step or the novelty of the invention. And it includes the patent and non-patent literature. The second type of search is validity or invalidity search, in which so we check if suppose there is a patent already granted and we want to check the validity of the patent, or if we want to invalidate the patent, we will have to conduct the search before filing the patent like we would know like what was the date of filing of the patent application. We will have to check if there was any prior art published before the priority date or before the filing date of the patent, and then based on that, okay, so if we found anything, then we can invalidate the patent. We can say that the patent shouldn't have been granted because there was already a prior art available with public. And it involves the claim mapping for each prior art. So claims are the part of the specification for which the patent is granted. Okay, so I think in next lectures the forms or the parts of specification will be covered, and then you will understand better in a better way like what are the claims. But in the specification, a lot of things are there, like title of the invention, then description. You will have to describe the invention. So claims will only cover the novel and inventive feature of the invention. So for example, maybe your invention is related to washing machine. Okay, there is an existing washing machine, and then you have an additional feature which is not there in existing washing machine. So when we talk about the description of the invention, you will have to explain everything about the washing machine, all the features. But when we're talking about the claims, it will cover only the novel and inventive features of the washing machine. Okay, what was done by you. But in description and background, we will have to cover everything. So when we check about the validity, we will have to see what was there in the claims. Then a knockout search. So knockout search is so sometimes we have a set of inventions, and we will have to see whether maybe before filing patent application we do, and to understand if there is a prior art available. So knockout search, we would get a prior art, and based on that we can modify or improve the invention to come up with the patentable invention. Then there is a competitor watch. Competitor watch means we are checking on the patent which are granted to a specific assignee or the inventor. So sometimes when you do a competitor's technology analysis, so for that you will check, okay, so if you're checking only for Samsung, if you want to understand how many patents are there in the name of Samsung, so you will check with the name, okay, Samsung. Or if you are looking for all the patents applications filed or granted to an individual inventor, we can check. We can check with their name, and then we understand the number of files, application number of granted patent, and what is the legal status of each of the applications. And we can also form a trend, okay, so this particular competitor, what is the patent filing scenario for them, or like what is the patent grant scenario for them. Then there is next is freedom to operate search. So freedom to operate search is so see, freedom to operate. Okay, I have an invention or I have a product and I'm going to launch the product in the market. Before that, I should know whether I have freedom to operate it or not. So before launching any product in the market, we do freedom to operate analysis to check that the product should not infringe anyone else's patent. Okay, so because see, you are working on the patent, you have spent a lot of time and money on research, and when you launch the product, again you are spending money and the time of yours. And after launching the product, if you get a notice from the third party saying this is our patent, you cannot operate the product in the market, then it would be very difficult. So it is always advisable to do a freedom to operate analysis before launching any product. Then infringement search. So infringement search is being used for the product, okay? So infringement search can be considered like opposite of freedom to operate. So if already there is a product or process in the market, and we want to understand whether the product is infringing my patent or not, or maybe the product or any available literature to it. So that is infringement analysis when we do. So I have a patent application and I want to understand whether there is a product in the market is infringing my patent or not. So for that, the search or analysis we do, that is infringement search. Backfire risk assessment is usually being done for the competitors. Okay, so if there is any overlapping in their own products, then we will have to see. Suppose they have a product which has a patent on it, and then they are coming up with a new product which also has a patent on it, and we see, okay, so the first one is infringing the other one. There is an overlapping of claims on it. So for it to understand all that, backfire risk assessment is being done. And patent landscape, as I already explained, patent landscape is to study the technology, specific technology. For example, if we want to understand the patent landscape related to artificial intelligence, all the inventions which has AI feature in it, and then we specifically conduct a search to get the results for AI related inventions, and then we put graphs. Okay, we need to understand the trend. So we will be getting a graph or the bar chart to understand. Okay, so what is like how the graph is moving, whether the AI related inventions are increasing or if it is already saturated. We need to understand what are the top assignees or top filer, the owner of the patent with AI related inventions. And what is the geographical coverage? Geographical coverage means we will have to see how many patents have been filed or granted in each country. So it could be a specific country wise patent landscape or technology landscape. Otherwise, it can be worldwide as well. So based on the requirement, we can put the chart, and uh, it also helps to understand the white and gray area. So suppose if I'm planning to do some research in any specific technology, and if I do a patent landscape before that, okay, and if I understand, okay, there are so many patents already filed and granted in that particular area, and we will also know, okay, even in the specific area there will be subcategories. So how many patents are there? So suppose if we understand the that particular area is already saturated, so there is no point spending more time on doing research on that particular area. Maybe we can identify other kind of technology or subcategory of the technology for more research, so that we also come up with something which is already not known or identified by others. So when we do patent search, there is an option of patent citation. Okay, so citations are the references. If I say in simple language, these are the references. If you know about the technical literature, we see whenever we are writing a technical literature, or we are sending anything for publication in journals, we can mention the references. Okay, we have got information on these prior published papers, and we are covering that information in our paper. So these are being called as citations or references. So for the patent search, there could be a backward citation or forward citation. So when I say backward citations means, so I have a patent application. So all the backward citations means the prior art, okay, on which my invention is, maybe my invention is the improved version of that. Okay, so all these references which were there before filing my patent application will be considered as backward citation. And these are basically checked by the examiner during the examination of the patent application to understand, to see whether the invention is patentable or not, whether the backward citations are killing the novel and inventive features of the current patent application or not. Then we come to forward citation. So forward citations means this is my patent, and my patent is being cited in all future patent applications or non-patent literature. So these will be considered as forward citations. Okay. So when I say backward citation, the citations which were used in my patent are backward citation, and the my patent was being used as reference, though those will be considered as forward citation. So forward citation is publication that has cited the specific patent application. It identify the competitors who are using similar technologies, because if most of the times there are other people who are working on the similar technology, your patent will become the forward citation for them, and it will help to understand the other people who are working on the similar tech. Higher the forward citation, higher is the interest and value of the patent. Okay, so number of times your patent is being cited by others, it can be considered that your technology or your patent or technology in the patent application is very good, and then your patent is of high value. But there is one thing I would tell you, like in one company, if you see, because I have done a search on this, I have published a paper also on the citation search. So mostly forward citations will be there by the own company or the set of inventors. Okay. So one, I have a patent application. If I'm filing patent application in future, I will be using my patent as forward. So as backward citation, but for my patent, it will become the forward citation. Or there will be a different examiner, or sorry, different inventors in one company. So most of the times their patents are being cited. So here you are acknowledging the work of the inventors group. So it could be. So when we are talking about whether the patent is important or is of high value, so mostly the forward citation where it was cited by any third party which has no relation to us, then we can consider. If there are multiple citations, okay, so then my patent is important. But if I say my patent was cited in other 50 patent or non-patent literature, and all those were my friends or working in the same group, in that case it cannot be said because it's a valuable patent or not, because it's like known reference, we are referring each other's work. So next is patent classification. Okay, so there are different classes being assigned based on the technology or based on the technical field of the invention. Mostly the classification which is used, that is International Patent Classification, IPC. There is Cooperative Patent Classification and US Patent Classification System. Excuse me. So these are three kinds of classification systems which are already there. International patent classification is important because this is being followed by all the patent offices. So, for example, US patent classification system is there. So when we see any of the US patent, it would be having both classes, okay? Because IPC or International Patent Classification needs to be followed by everyone, and then every country can have their own classification also, but they will have to mention both. So CPC, that cooperative patent classification, is based on IPC, means main classes will be same, but it gives more features or more sub-levels based on the specific technology. So classes, when I say there are sections A to H, A, B, C, D, E, F, G, H, which is there in international classification. There is additional category in as Y, so which is there in CPC or cooperative patent classification, that covers the because sometimes we are coming up with the technology, new kind of technology. So if there is any technology which cannot be covered in A to H, in CPC they have added one Y category. So all those technology and all those relations will fall in Y category. So I have given the link to both the CPC and IPC here, and I think these presentation will be shared with you so you can access and you can explore this, how does it work. I have added few snapshots like to show you like how does it works. Maybe that will be helpful for you. Because see, patent search it's difficult to explain. I can tell you the process, okay, how to do the search, but to understand it practically, you will have to do it, because the more you do the search, you will come up with the refined features of it or the refined results. So this is CPC. So for example, I'm checking like what would be the CPC class for steam ironing. So you can see is the section is D. We can see D section, and then on the D06. So if we say section is D, and then subsection 06, and then we can see further classification. So 7300 is apparatus for smoothing or removing creases from garments or other textiles. So that's how it explains things. Okay, most of the things will be in broader form. So we will have to identify the class which is relevant to my product or my process. Okay, so here you can see 7500 hand irons. Okay, then these are the sub part of it. Okay, so 02 is externally heated hand irons. Then 04, so this is, you see one dot. Okay, so 04 and 06 are part of this. Okay, so externally heated hand irons. Then we can see there are two sub part of it: by preheated block or by means of supplying steam or liquid to the article. So based on the dot, so next is 7508, hand irons internally heated by electricity. Then you say, okay, with means of supplying steam. So there are further bullets. You can say this is the sub feature of the earlier one. So this is CPC. And so the same way there is a example for MRI. So you see it's like it's in it may be in section G or A. So if you read the features, you will understand. So G01R, it says arrangement or instrument for measuring magnetic variables, while A talks about measuring of diagnostic purpose. So accordingly, we will have to identify, and this is very important when we want to do a search on a particular technology, because when we do a search on particular technology, we can identify the patent class for that, and we can use the class as a search term to check. Okay, in that case, the results which will be extracted, that will be all related to that particular technology. So for that, first we will have to identify the class. Okay, and it comes with practice. Okay, so once you do it, you will understand how to identify the classes. This is international patent classification. So you can see the categories here, A to H. Okay, and so these are the categories. And then if you put steam iron here, you can see the results. So now, next we will have to see the search strategy. So it depends on the type of search. I explained there are different kind of searches: patentability search, knockout search, freedom to operate search. So based on the objective or the requirement, we will have to make a strategy. Like one strategy will not work for all kind of searches. We will have to make the keywords and then identify the strategy based on the requirement. So for example, for patentability search, the focus would be on all prior arts, whether it's patentable or non-patentable literature. Okay, we cannot afford to miss any prior art, because if we miss anything before filing the patent application, same will be cited by the examiner during the examination. That may not be good for us. For technology landscape, we will have to get the maximum coverage with respect to a particular technology. Well, when we say patentability search, we are talking about the special features. Well, in technology search, we are talking about the technology. Backfire risk assessment, we will have to focus on assignee because we are talking about the competitors or a particular owner's patent. So we will have to check the related patent granted to an assignee or the owner, and then what is the legal status of each case. Assignee specific search or competitors watch is being done using a name of the assignee. Okay, so we will have to see how many patents were awarded to a specific assignee, or we will have to check the assignment also. Maybe the patent was granted to some other owner and later it was assigned to a assignee for which you are looking for the patents. So if I have added like one like very small, it says GE sells its appliances business to hire for $5.6 billion. So these appliances might have been, the patent might have been granted to GE, but when these were, no, just a second. I'm so sorry. So when we say the GE sells all these appliances to hire, so in that case, maybe the patent was awarded or granted to GE, but when it was sold to a different company, there might be a patent assignment also. So we will have to check when we do a assignee search, we will have to see, okay, who is the current owner or current assignee for that particular patent. So strategy, how do we make the strategy? So first thing, we will have to read the invention. Okay, so we will have to read the invention. We will have to identify the invention to see. Like first, we should know what is required from our side. What is our objective to do the search? So one thing, okay, we will have to see the invention disclosure, which is actually explaining about the invention, prior art, everything will be there in the invention. So accordingly, we will have to identify the main features of the, so these are the keywords we create. Once we read the document, we will have to identify the keywords from it because we will have to see, make a key string. So first we will identify, or maybe we can just underline the important words used in the invention. And then accordingly, we will have to list out all these keywords. We will have to identify the synonyms of it. Okay, so maybe you are using one word for it, and then in other patent application, they might have used a different synonym. So if you are using the exact word, you may not get the other patent which is not using that word, though it is related to the technology. We can also identify the classes that can also be used in the search term, and accordingly we can update. Okay, and then we will have to formulate, there might be different key strings or the queries. So queries are the key string which we put when we conduct a search. For example, when we are checking something on the Google, we just type the word and we get the results. So if the results are not relevant, we rewrite the key strings, or we change the key strings based on the results we get or based on our requirement. The similar thing is being done on for the patent search as well. And then we will, so whatever documents or the hits we get, so we will have to screen the documents. We will have to see whether the documents are related or not. So for patentability search, we will have to see whether the results we are getting of this from the search, whether it's helping to assess the novelty or inventive features of my invention or not. So it, for invention disclosure, there will be a title which is very important when we conduct the search. And then the second point, what we consider is like what was the problem in our invention which is being solved. Okay, accordingly we can identify then what is the stage of development of the invention. Suppose I'm doing the search, I'm still developing the invention, and maybe I may come up with the final invention after 6 months. So we will have to identify the keywords based on that as well. And so invention, okay, that would be required we need the document to be detailed. So suppose when I'm conducting a search for a client, we will ask them to describe the invention in detail for my better understanding, because only then I would be able to identify the exact keywords. If the applicant is sharing this half paragraph or one page document with me, I may not be having actual information about the invention, and that may be an hindrance when I conduct a patentability search. And competitive advantage, what is the closest existing or non-technology? That's what we need to understand. And then what are the advantages and benefits of your invention over these competitor approaches? All these things are being considered when we conduct a patentability search. Technical application of the invention, public disclosure, suggested list of keywords and synonyms. So when we conduct a search, and so I have my invention, and then I'm getting maybe 10 documents related to similar inventions. So after that, I will have to compare. Okay, I will have to compare the features of all my invention with theirs, and then accordingly we will get to know. Okay, because sometimes I have the information. Okay, the inventors, they gave us a write up, and there may be certain other things which were there that they forgot or they are not considering that is important to share. So when we share the results with them and ask them to differentiate each and every feature of the citations, what we get in the search results, most of the times the inventors are coming up additional features of the inventions which were not shared earlier. So based on this additional features, we will have to rework on the searches. We may have to modify the strings, and then we will have to research it and to get the other results. These are the few databases. These are the free databases available to public for the patent search. I have covered snapshot of it. So, but to understand it in a better way, you will have to check each and every database, like how is it functioning, how do we rephrase the searches and get the search results. So there's a Google patent. It's covering the broader invention from the multiple countries. eSpaceNet. So in eSpaceNet, this is European database. There is an option where we can set worldwide or global patent search. It will cover the patent search results from across the global, or like most of the countries are being covered in eSpaceNet. USPTO. This is from the US Patent Office website. Here you will get only the patent applications filed or granted in US. Patent scope is for PCT application when we file. So there are applications being filed. So there's one PCT application, international application when we file it. And if we want to search anywhere there, so that is WIPO or PCT database where you can search the patent application. Then Indian Patent Search Database, it will give you the results only for the patent applications filed or granted in India. You will not get the results from any other country. So this is Google patent. Okay, so if you see the search results here, it says this is the example of MRI. So magnetic resonance imaging, okay, or MRI. The people can use both the words, okay. And this is the classes, okay. I have shown you there. So there were two different kind of classes. So the G series G and section G and section A. So I have covered both. So it could be either this or this. Then assignee, if I'm looking specially for maybe Philips electronics, I can put a filter for Philips. So on the left side, you can see the search terms here. So these are the search terms. These are the words being used in anywhere in the document. These are the classes, either this class or that class. And if we want to put the priority, okay, so I have put here like 1st January 2010. So it will not show me any patent which were filed before 1st January 2010. It's just showing me the data after 1st January 2010. We can put a filter also. If we are looking for specific, maybe 5 years data, we can put like from this date to this date. Accordingly, a filter can be put. And then assignee, I have put like one assignee. So we are checking only patent applications files are granted by or to Philips after 2010 related to MRI, which falls in specific patent classification. So it's showing me 676 results. So these are not like when I was working on the presentation, that time I have done it and the screenshots were taken at that time. So maybe today, if you are checking it, it may show a different search results to you because it might have been added like the recent ones. So here you can see, so in the Google search also in the text, you get options, okay? So there's a full document. If you select full document, the term you are putting here, it will check whether the term is being used in full document or not. Otherwise, if you want, you can put a filter. You can select the words only in title or maybe only in abstract or claims, or maybe these are, okay? So here, and then you can also put, okay, so exact words. So if you want the exact word to be selected, or maybe there are multiple options available, and accordingly you can select. And this is eSpaceNet, that European database which shows worldwide information. So you say all text fields, magnetic resonance imaging, or MRI. Okay, and then in the Philips, I have mentioned only Philips. Okay, and I have selected any. So means apart from Philips, there could be something else as well. So sometimes the name of the company may be different in, there will be slight change in the name in different countries. So if I put Philips, it will show all the assignees which has Philips in their name. And then for classes also, we have selected either this class or this class, okay? And then you see the operator here, or. So I'm selecting this or operator for these two, okay? So this or this, it will show me results for both. And if I put and here, it will show me results only which has magnetic resonance imaging and MRI both. If either this or MRI was used, it will not show me in my results. So accordingly, we will have to make key strings to get the relevant results. So usually it is being advised to start the search with a broader category, and then you can refine as per requirement. So this is the snapshot of WIPO patent scope. Here we can see the option, that field combination option is there. By default, when you open this page will open. So if you have only one term, okay, so if you just want to check for MRI front page, or you can here select all and you select the term, it will show you the results. Otherwise, we can go for the field combination. In the field combination, the page will be like this. So here we can check, okay, so front page, we have put two words, this or this. Applicant name, I'm putting Philips. Classification, if I don't put it, it will show me all the classes. And if you see operator, I have put op and operator here. That means it will show me the result which has magnetic resonance imaging or MRI, and applicant name is Philips, okay? It will show me the results accordingly. So here you can see the results, and there are a total of 143 pages. So these many results are there. And if you see, based on the words I have put, okay, so that MRI, so you can see that magnetic resonance imaging or MRI, it is mentioned in it, and then Philips is mentioned as an applicant. And this is IP India, Indian Patent Office website. It looks like this. So accordingly, we will have to, so there will be different options, okay? So yeah, there will be searched field here. So by default, maybe it's showing title here. If you want to put something else, there will be multiple options in drop down. You can select any of these. While like the title and abstract, these are there in like in the order, but if in the first you want to put something else, you can just select an option from the drop down box. and then you will have to enter, and then operator options are also here. Accordingly, you can select and, or, not, whatever. So based on the searches, if I saw, so these were the hits what I got. So when I'm checking for magnetic title, there will be like sometimes the results are not correct. So this was done in March, like 2023. And with the title magnetic, I'm getting 2760 hits. And when I put magnetic resonance, it says 2888. So usually when I put magnetic, there should be more results, and when I put when I'm putting additional words, it should restrict it. But you see, it's actually increasing the numbers because it's showing it with uh, magnetic or resonance, and then magnetic or resonance or imaging. That's why the numbers are getting increased. So it happens. So sometimes in Indian Patent Office results, we may not get exact required results. So these are the typical features in common search what we use. So search forms could be a quick search. It can be in the field search, or maybe if there are advanced option, we can put an expert or command searches. Searches fields. So there are different kind of search fields. It can be in also fields. We say it maybe for words. It could be anything which is in the specification. For example, claims, title, abstract, or description. It could be a classification or assignee, inventor, date. Even you get other options, maybe assignee country, inventor country. All these things are there. You can also select base. So all those worldwide databases, you get option to um, put a filter based on the country as well. It's like it's a worldwide search, but if you want to see the results only for India or US, that can be done. Then Boolean and proximity searching, you can put operators, okay, and, or, not, near, adjacent. So every database might not be having all the features, okay, but these are the features available and can be used. Then truncation, maybe left, right, middles. So we can put truncation. For example, if I'm checking for maybe chairs, okay, and then if I put chairs, CHAIRS, it will show me results only where chairs is mentioned. It will not show me results with chair, without S. So in that case, we can put CHAIR, and then I can put a truncation question mark. That may also change. Mostly it's same. So it when I put chair trunk and then question mark, it will show me the results with chair, chairs, or after chair if there is anything. And there will be other fields, time, where we are specifically looking for specific years, whether it could be a date of filing or publication or the priority, or assignee, inventor, assignments. We can specifically require, as per the requirements, we can put these filters. Citation search, this can be done. Maybe we can check for forward citation or backward citations. These options are available. Then the query combination. Okay, so there could be a combination of queries of all that. Okay, so I am using single words or synonyms of it, along with the combination of assignee or year or the classification, citations. So we can just mix the combinations, and accordingly we can come up with a search string, and that can be used, and that will show us the result. And based on the result, I earlier said, the filters can be put. Okay, so if the results are not required as per your requirement, we can change the keywords, or we can put more filters if the results are so much. So this combination, those we can use operators and, or, not. And assignee lookup. In assignee lookup, we usually check for with the name of the assignee, irrespective of the classes or irrespective of the year. I just want to know the number of patent applications filed or granted to one assignee, maybe Phillips. So we can just put the Philip's name and we get the results, all the results, and we'll get to know. Okay, so and see, usually when we do the searches in these free databases, for example, that US patent database, Indian patent database, or European patent database, or maybe in Google, we get the results. But when we talk about the paid searches like Thomson, and there are other paid databases available, where see we will have to put the search terms, okay, but they will give us the refined search. They can prepare a report for us. For example, if I'm checking the assignee look, if I put the intervent, the name of the assignee, it will show me all the results. And if when I want the report, in the report, it can prepare the report for me in the graphical form. So I don't have to do it manually. Otherwise, when we do manually, we will have to copy paste all the results in Excel sheet, put a filter, they sort it out all the results, and accordingly we will have to put a graph manually. Everything will be done manually. But in the paid databases, all these are available. Just you will have to click the button, it will prepare the report, and immediately you can see the graphs for the what is the filing trend, or what is the grand trend for a specific assignee. And similarly you can see for if we are doing for a particular technology, we will get to know, okay, what are the main players or the competitors in that particular technology. All these reports will be generated immediately. So in this one, this is what we have covered. I have covered the invention, like how the technology is being evolved and what is the invention, and the patentability criteria when the patent search required, types of searches, citation search results, classification, search strategy, all these is being covered. Okay, so in the presentation I have covered everything. If you have any queries on this, we can discuss it now.
I want to, I mean, if one invention has been done in a two different country, and one, uh, say, for example, who is in American and he did it, registered it. But another country, say an European country, so he did not register it already, although he has invented prior to that Americans. So now in this question arises that who will be the inventor then?
No, you said you have created something and you have registered in US, or someone else has registered in US?
The same invention, person, similar type of inventions, say machine development or aircraft. So whatever may be. So Wright brothers, they are claiming that whereas it has been found that in some other country the similar type of things has been done, although higher, I mean prior to the date of the Americans. So in that case, who will be the inventor?
So see, when we are talking about the patent, it's more on the assignee side of who is owning the patent. So the person who is filing the patent application first will own it. So suppose sometimes this happens, okay, so exactly similar invention not possible, but there are chances people are working on the similar technology or overlapping technology in two different countries. Okay, so I'm working in India, and
I think, and I'm what I'm telling, because there is an invention regarding this aircraft is flight more than 1 minute, which has been done by Wright brothers in USA. But similar things has happened that in Germany they have done prior to that.
so if they
So, but
have made,
we can
no,
consider
no,
that Wright
I
brothers
understand.
invented.
No, it depends. Okay, so if there are two people working on the similar technology or similar invention, when we are talking about the patent rights, who is filing application first will get the patent rights. Okay, so suppose I am working on a patent and in India, and you are working on the similar technology in US, and you have filed the application before me. Okay, so patent will be awarded to you, not me. Even if I'm filing if I'm filing after you in any of the countries, even in India or US, your application will become the prior art for me. But
I did not file it at all. Means say European country did not file at all. So now question arises, now as a general knowledge question, that who is the inventor?
so see, both will be considered as inventors. I was working in India, the other person is working in US. So both were working independently. So when we are talking about the credit, who will get the credit for the research, both will be getting the credit because they were working independently. Okay, filing patent application is different than working on the invention.
Okay, so registration is, compulsory.
Registration is compulsory if you want to enjoy your rights, if you want to enforce the patent rights. Otherwise, you don't have any right. You are just working on the invention. There are many people who are working on the similar technology. No one will say anything. Okay, so see, you don't have a patent on it. I don't have a patent on it. Okay, I'm working on a technology. You are also working on the similar technology. We are working in two separate cities or two separate countries. And so you cannot stop me because you don't have any rights. You can stop me only when you have a patent granted on this. You cannot stop me. I cannot use it. So because that's why I said the patent is negative right. It gives you right to stop others. So if you are working on the technology, you have filed patent application, and so now when later on when you get to know that someone other person is using similar process and taking commercial benefit of it, you can stop them because now you have a right. And it's only on the commercial benefit. For example, your patent is being used by maybe another inventor for research purpose or for teaching purpose. That is not being considered as an infringement. We are talking only about the commercial benefit when they are selling it, when they are making money out of it.
In that case, suppose the American, they are also making an aircraft with their own technology, and German is also making their own technology, and they are also selling into this market. So, so whether in that case, the one country can, no, you cannot sell it.
If there is no patent, anyone can sell anywhere.
Yeah, that's so.
That's why the patent. That's why the patent is important, and we get the patent, and then we can stop others. Sometimes there are different companies who are inventing a lot, but they don't want us to stop others, so they never file patent application.
It is there.
Right? Maybe if they don't want, right?
Yeah. Okay.
Okay. And there is one more thing. So I don't. So you must be knowing about this turmeric case of US, whether a patent related to turmeric, which was awarded in US, and then Indian government taken action against it. So when usually, like in general terms, even when people were saying, so it was being said as that US has patent haldi, or the US has patented turmeric, which is our turmeric. So that was not the case. There was, so the patent was related to an invention where the turmeric was being used as an antiseptic for the wounds. Okay. And the Indian government, they opposed it. Okay. So they said that the patent cannot be granted because use of turmeric on wounds was already known in India since ages. Like even today also, when the kid is getting hurt, the first thing mother would be putting is turmeric on the wound if they don't find anything else. So to put the Indian government has to spend a lot of time and energy, because when we cannot just say it, we will have to prove it. So we submitted few documents where the turmeric was used on wounds. It has wound healing properties, but that was not used. That was not accepted earlier because the US patent was talking about surgical wound. Okay, so when we say normal cut or surgical cut, there is a difference. And then in the for that also, the Indian government has spent again a lot of time. They were not able to find a single document which talks about use of turmeric on surgical wounds. And then finally, one document, there was very old Sanskrit document which found, and which talks about using the turmeric on umbilical cord when the baby is born, and then on the umbilical cord when it is being cut, and that time the turmeric was being used on umbilical cord. It is being, so that particular cut is being uh, uh, like accepted as surgical cut. And then use of turmeric, that means use of turmeric on surgical cut for as wound healing properties was already known, and based on that, that US patent was revoked. So this was traditional knowledge. And after this,
Understood.
because the Indian government was facing a lot of issues on locating the document, because there was no written document available. We were not getting anything where it was written. So after that, there was an amendment made in Indian Patent Act, says when we talks about traditional knowledge, they have included one word, oral. So even if the information is available orally, it will be considered. It is not mandatory that it should be a written document.
Ma'am, I have a doubt.
Yes.
I'll ask something. If I register my patent in some other country, and and I come to India, and in case of any dispute, I file the case in India that my patent is getting infringed. So, will that be accepted in Indian courts?
No, so if you have a patent registered in other countries, maybe in US, you have a granted patent in US, and you are taking an action against someone using the invention in India. You don't have a patent in India. You cannot do it because you don't have any rights in India. You
Okay.
can take action only if in the country where the patent is granted. That's why these IP rights are territorial in nature.
So I cannot go back to my country and file a case of infringement the person against the person who is trying to get the patent in India.
No. Who, if someone is trying to get the patent in India is different. Okay. If when we are talking about the patent rights, it's talk about the commercial. If someone else is taking commercial advantage of patent. Okay. If someone is selling, manufacturing, or offering for sale or importing the product in India, if you don't have granted patent in India, you cannot do anything.
Okay.
Okay, so
Okay.
based on the business, you will have to decide. So one thing, okay, so you are in India, your business in India. So obviously you will be selling the products or maybe using the process in India. The first thing you should do, you should file application in India. Then if you want to protect in other countries, so one thing you can protect in any countries. But again, what is the point? Like how do you decide whether to go for a specific country or not? Because there will be a lot of money involved getting the patent granted. So if
Yes.
you have any future plans to have business in that country, then only we advise to protect the invention in other countries. Otherwise, suppose you will never be doing a business in US, okay? Even you
Yeah.
don't have US investors or anything, and you have patent filed in India, granted in India, then you are filing patent application in US as well. It is granted in US. You will be paying money, the official fee and the professional fee to get the grant. After that, you will have to maintain it. Like once the patent is granted, renewal fee or maintenance fee needs to be paid for 20 years. So for that also, you are maintaining the patent, again spending money. And if someone is copying it, you will have to take action against the person. For that, again, you will be spending money for litigation. But are you getting anything out of it? Are you getting any business out of it? If the answer is no, like why will you protect the invention in other countries? This is just spending money.
Okay. Okay.
Uh, we are running out of time, but can I ask a question, Dr. Shivani?
Yes.
Yeah, so it was a very comprehensive explanation regarding the patent search, and which we, as sometimes as individual inventors, also understand the need of the prior art search. One very important thing that I saw was when you mentioned MRI, we had a search result of about 600 plus
Right.
patents that have been granted or published or whatsoever. Now,
Right.
as an individual inventor, like you said, if it is a subscribed model of the patent prior art search engine,
Hmm.
there it is possible for us to get a sort of a report. But in case of the what is available in the free space, we don't have all those. We have to prepare our Excel sheets and all of that.
Yes.
Now, is it sufficient as an individual inventor where I just want to understand what is the level of inventive step in the subject matter that I want to patent? Is it enough if I just read the abstract of each of these? Because there are like 600 plus documents for me to, even run through. So how do IP attorneys usually pick on these and get the right report?
No, see, so suppose if you're getting 600 results, and even on the paid database, when I'm talking about the report, it will maybe one report could be when we are talking about the landscape. Okay, it will give us the data that the graphs, different graphs. Okay, so those graphs are not helpful if I'm doing a patentability search. Okay, for patentability search, we will have to understand whether the other inventions were novel or not. Like my invention is novel or not. So for that, I will have to read the document. So when the kind of report we get from the paid or subscription based databases, we can select, okay, we can download the report with abstract. Okay, because see, downloading the report with everything would not be feasible. We can download the report with abstract, and mostly I can say 99% we can get an idea if we see the title or the abstract of the invention to understand whether it is relevant to my invention or not. See, practically, see, when I conduct the search, by default, I would be checking on USPTO. Most of the countries, they file application in US or other worldwide searches. I prefer doing that. Though I don't do it this on a daily basis, but whenever I do the search, I check for maybe the worldwide, that eSpaceNet, that European database. And because in the summary, you can see the abstract, you can see the title, and then when you click it, you can, so all those documents, you will have to click and open the documents to read it.
Yes.
Okay, so that manual reading will be required even if it is the subscription based database.
Okay. Thank you.
Thank you.
Ma'am, this is Rani. If someone has already filed for a patent in the US and he has been granted a patent, but a similar invention has now been conducted and done in India, and the same person in India goes to file a patent, the patent no longer remains to be novel. So will he be granted a patent again?
So if the patent is already granted in India, so in US, and later he's filing application in India, there are time limits for that. Okay, so when we file first application in any country, within 12 months, we will have to file in other country. Okay, so I have filed application in US in maybe on 1st January 2023. And if I want to protect the same invention in India, I will have to file within 12 months, like 1st January 2024. Otherwise, there is a PCT option where we get additional 18 months. So, but we will have to follow the timelines. An application can be filed. So you can file application in US and India as well, and you will be granted patent in India as well, unless you file it within the given time.
Okay.
There are people who are filing in one country, or maybe at a time they file in 20 countries, and they would be having patent granted in all 20 countries. So this is same or similar invention, but when we are talking about number of patents, these are 20 patents.
Thank you, ma'am. Ma'am, is it a bit difficult for students and people from legal backgrounds to do patent searches, because these might get a bit technical?
Okay, so I'll give you just one example on this one. So not about the patent filing, but when we talk about the litigation matters, when the patent infringement is happening in the court. So mostly, so now we have specialized IP courts, but earlier it was not there. So most of the times, the lawyer who is fighting for the case, who is putting the arguments, and the judge, they might not be having legal background, but they do that. But obviously, support is required from the technical team. So if you're a lawyer without technical background, you may have to spend more time to understand the technology, but you would be able to do that. That's all. If I'm a lawyer and I have a similar technical background, it would be easier for me to understand the technology. But maybe if you don't have a technical background, you will have to spend more time to understand the technology. That's all.
Okay, ma'am. Thank you.
Do we have any other questions here? I think we can wrap up the session then. Thank you so much, Dr. Shivani, for this wonderful, wonderful session. And thanks for sharing the practical insights on the topic, and it was indeed very engaging and very interactive and informative. Now, those who have already registered with us, you can complete all the related assignments. It's there on the portal. And thanks again, Shivani, Dr. Shivani, and thank you all the participants. I think we'll take another break for like 5 minutes, 11:15. Maybe you can join back for another session with Mr. Pankaj, and he'll be conducting a session on filing of patents and PCT filing.